Good morning, everyone, and welcome to our webinar today, all about IP strategy for software. While we are waiting for everyone to join, please feel free to introduce yourself in the chat and let us know where you're joining in from today. And you can also use this opportunity to quickly network with like-minded people here. My name is Leah, and I am here from Invest Ottawa. Thanks to the support of the partners that you can see here on my slide, we're able to be here today and offer other webinars throughout the year. We are also able to provide you with free business consultations, so a one-on-one with an expert in the field, and also many different programs. So if you're interested in any of these services, please feel free to shoot me a message after the webinar, or you can also find out more about these services on our website. Now to the house rules for today's workshop. This session is being recorded, so after the workshop, you will get a follow-up email from me with the link to the recording and also a copy of the slides. So this will allow you to really go over everything again and answer any possible questions that you still might have. If you have any questions, and I highly encourage you to ask your questions, please use the Q&A function that you see at the bottom of the screen, and we will answer them as we go throughout the presentation or then at the end during a Q&A time. Your microphones are muted and the cameras are off as well, so our focus truly is on the presenter. And this brings me to our speaker we have with us today. We have Jeff Leuschner with us. Jeff has practiced intellectual property now for over a decade and always with an emphasis on patents. And he is a partner with Smart Biggar. And this being said, Smart Biggar is a partner of Invest Ottawa. So we couldn't be more thankful for you being here today, Jeff, sharing your knowledge and insights with us. And I'm just going to hand it over to you.
Thank you, Leah. So I will share my screen now, and just give me a second here. Slideshow from beginning. Okay. So like Leah mentioned, my name's Jeff Leuschner. I'm a patent agent and partner at the law firm Smart Biggar. Just by way of context, Smart Biggar is Canada's largest law firm that specializes only in intellectual property and technology law. And we've been serving the Ottawa community for a long time. We've had an office in Ottawa for about 100 years. So it's, we're not a name that's maybe well known to everybody, but we're a business that's been in Ottawa, serving Ottawa for many years. And we're also happy to be partnering with Invest Ottawa. As part of that, we do some IP clinics, and we have these what we call master classes, including this one. And of course, as you know, we're here to talk about IP strategy, more for software and computer technologies, although some of the messages here will be more broadly applicable to any sort of technology that might form the basis of IP in your business. So you're welcome to ask questions as we go along, but there will definitely be time at the end for some questions. So I will get started, and thank you for the next hour or so. Now, a lot of times when an IP practitioner such as myself is interacting with a business owner, like perhaps yourself, it's very easy for the conversation to turn to topics that the IP practitioner is most comfortable with. So the IP practitioner might be talking with the business owner, and it might become clear that the business owner would be well served by potentially having a patent. And so it's really easy for the IP practitioner to start talking about what a patent is, the legal and technical requirements, the costs, etc. And if you were to hire that IP practitioner to get you a patent application filed and to obtain a patent or some other IP right, or maybe in like some sort of litigation or something, you would find that that IP practitioner would probably be pretty legally and technically minded, focused kind of on tactical short or medium term goals, like how can I get this patent application we filed through the patent office to a patent? Or how can I advance an argument that's going to persuade a judge or an examiner or someone to see the argument that we want to advance? And that's, well, fine, that's fine. I mean, you want to have an IP practitioner that is good at what they do, and hopefully they would be if they're, they're from a reputable firm. But sometimes the business owner could be wondering or ask themselves, that's all well and good, and obviously you would be good at what you do, I would assume, but really, what does this pursuit of IP rights and your talk of IP strategy, etc., where does that really fit, and what does that really have to do with my business? Because I'm not in the business of, for example, getting patents and suing people. I'm in the business of delivering some sort of product or service to the market that hopefully customers are going to love, and it's going to be a solution that's going to be very commercially successful. Where do IP rights fit in that picture? And so when you're speaking with an IP practitioner, you want to make sure, to the extent you can, that you're trying to draw out of them some of that more business value. What's the kind of the business case here for IP rights, and how does it fit in terms of the perhaps longer term and strategic goals and business objectives that themselves have nothing to do with pursuit of IP rights? So what I'm going to try to do in this talk is to focus more on messages on the right-hand side of the slide, and not saying I'm perfect at it. I mean, I'm a victim of being a patent agent also. I'm technically minded and tactical, but we're going to focus on more the business-minded conversation, talk less about the nuts and bolts of how you get a particular IP right, and talk more about how you can think about them fitting in the context of your business and your business objectives that probably are really independent of IP. So with that being said, I'll start with a story. This gentleman on the screen here, his name is Sir Humphrey Davy. He was a Englishman from the late 1700s, early 1800s. He was a well-financed, well-educated individual. He was a research scientist. He was president of the Royal Society. As part of his research, he experimented with electrolytic cells, and he developed the first electric battery. And in 1802, he took some copper wires and he connected one end to the battery and the other end to a piece of carbon, and that piece of carbon began to glow. He essentially developed the first electric light bulb. He called it the electric arc lamp. So he did something that the Oxford English Dictionary defines as invention, something that has never been made before, or the process of creating it. Now, from a business perspective, you could say, you know what he did? He took money and he turned it into technology. I mean, that's often what kind of invention is. Like a business will put some resources, which ultimately is money, into maybe some R&D, and the outcome of that is some sort of technology that hopefully can form the basis of a product or service. This gentleman on the right-hand side, his name is Thomas Edison. You probably know him better than Sir Humphrey Davy. Thomas Edison, in the later 1800s, he took that existing electric lighting technology. He made some substantive improvements to it to make it commercially viable, and he began selling electric light bulbs under the Edison Electric Lighting Company in the 1870s. So he did something that the Oxford English Dictionary defines in one way as innovation, the action of introducing a new product into the market. Or maybe said another way, he took technology and he turned it into money. Now, the reason I start with this story is to help set the context. When we're talking about IP rights and potentially pursuing an IP right or doing something in a sort of formal way relating to your IP, we're not talking about invention. We're not talking about protecting invention or rewarding an inventor. We're simply talking about these tools that exist that are really just one set of many tools that the business probably has access to. It's going to help, or that you want to try to help, with the goal of helping to protect your ability to turn your technology into money, or as in Oxford English Dictionary defines in one definition, innovation. So we're going to talk a bit about that, maybe at a kind of more granular level with a hypothetical example. But let's just step back for a minute, forget about that specific thing, and let's just think about Canada as a country. Now, Canada, if we go back just over 20 years ago, in 1999, we were the 8th largest economy in terms of GDP. We had a large primary sector component of our economy. That's the component relating to natural resources like lumber, oil, gas, agriculture, etc. I mean, traditionally, we're a rich country because we're rich in resources. But aside from that primary sector component, if you looked at some of our policies, you would see policies that were focused on mitigating deindustrialization. So factory jobs were starting to leave and go to Mexico. And we had policies like tax incentives in place to try to mitigate that. So fast forward 20 years to 2019. I don't have the 2020 stats yet, but in 2019, we were the 10th largest economy in terms of GDP, perhaps dropping down to 11th soon because South Korea is growing. We still have that large primary sector component, no surprises there. But outside of that, outside of our natural resources, if you look at some of our big policies, you'll see one of them or some of them are policies that are focused more on what we might call the inventing side of things rather than commercialization. So R&D. And a perfect example of this is the Scientific Research and Experimental Development Tax Credit, or SRED. And I'm not an expert on this tax credit, but what I do understand is that it's one of the most generous tax credits in the world relating to research and development. It awards about $4 billion in tax credits each year to about 18,000 claimants. And it's a tax credit that rewards and encourages invention, R&D. So you can get that tax credit potentially to, say, hire an engineer to help develop something, do some sort of research and development. But you're not going to get that tax credit to hire a business person to commercialize that product, or to hire, say, an IP practitioner to help with an IP strategy and to help funding for a first patent. Really, it's a tax credit that's focused more on the invention side of things and not on what we defined in our last slide as innovation, at least in the sense of commercializing. So perhaps because of this, some of our policies, and perhaps because of maybe our culture as a country, and that we are kind of a small player compared to our neighbors to the south, it's been perceived by several academics that Canadians are pretty good at coming up with things that are smart, inventing, but they're not as strong at the commercialization and commercial leverage side of things in terms of capturing and holding the IP rights and using that for commercial leverage, whether it be in the context of becoming a dominant market player or an acquisition. And you see this when you look at some of the literature. For example, the Council of Canadian Academies a few years ago authored an extensive report on the state of innovation in Canada and mentioned, among other things, that patents invented in Canada are increasingly being owned outside this country, and that outflow is accelerating. In other words, we have a lot of smart people inventing things, but the IP rights and how you can leverage them, all that's being expatriated and going to foreign companies. Eric Schmidt, he's the chairman of Alphabet, which is Google's parent company. He was sitting down to a fireside chat, if you call it that, with Justin Trudeau a couple of years ago at the Google Go North conference in Toronto. And Eric mentioned, among other things, that to thank us as Canadians for inventing all this artificial intelligence stuff, because we now use it throughout our entire business, and it's a major driver of our corporate success. So we owe you, right? Another kind of anecdotal example of, where Canadians are inventing stuff that's commercially useful and viable for companies, but it's going to the foreign companies in terms of protecting it and leveraging it. Excuse me. One last example. Jim Basile, the former co-CEO of Research in Motion, now BlackBerry, co-founder of Institute for New Economic Thinking. He writes a lot on this topic. If you look him up in the Globe and Mail, he's written several opinion pieces. One a year or so ago was in the Globe and Mail, where he commented that over the past 30 years, commercialization of intellectual property has become a primary driver of new wealth. Yet, as a country, we continue exporting those low-margin resource and agricultural goods while importing high-margin IP. So the thing that's kind of interesting is that this commentary, it didn't go unnoticed. So the federal government, about a year, more than a year ago now, probably about 2 years ago, they took notice to this, and I do have to applaud the federal government for doing this. They said, you know what, as Canada, as a country, we need a national IP strategy. Now, where the criticism starts to come in is how that's being executed and what that looks like. So the government has announced a series of programs, and they still kind of do here and there. So this is part why I'm telling you this, to keep an eye on it. But they've said they've had some ideas as to how to kind of have a better IP position in Canada. And some of the programs that we put some taxpayers' money into include these things called innovation superclusters. So this is where like academics, SMEs, and big companies collaborate to develop some IP. There's one for artificial intelligence in the Montreal area. And I mean, I guess this sounds good on its face, potentially, but there's still that outstanding question of, so what's going to happen to the IP rights? Will they be pursued? Who's going to hold them? What's going to be the benefit for the taxpayer or for Canadian companies? There's money that they put into IP legal clinics and IP awareness and education, which on its face I think is great. They also funded these somewhat kind of unique and obscure programs that are really a response to some strong advocacy groups. So they have something called this patent collective, which essentially is this idea where SMEs can pool their patents and share some best practices on building and defending IP portfolios and strategies. So they've given a bunch of taxpayer money to this organization called the Innovation Asset Collective, which is working on building something along these lines in the clean tech sector only. So we'll kind of see what comes of that, although it's kind of a very unique program compared to what you'd see in other countries. Now, if you look at kind of the execution of this IP strategy, a critic would say, well, maybe this is all well and good, but what's the path to the finish line here? And I assume what it is that we would want to encourage a Canadian company to be able to strategically file and use registered IP assets like patents, which we'll talk about, to give them some sort of commercial leverage, some benefit in the marketplace. And the question is, does this aggregation of programs as part of the IP strategy, does that get us there? And I think some critics would say it doesn't. There's some ideas of some things that the government is encouraged to pursue, but they're not necessarily cheap. But there's some instances where they've worked well in other countries. One is a national first patent program, so some sort of funding relating to allowing a company to be subsidized, engaging an IP practitioner for some IP strategy and a first patent. Patents are expensive, as we'll talk about briefly later. There's this idea of maybe an innovation box. So this has worked somewhat well in the UK. It's basically, you can get a lower tax rate on income derived from IP, which is a pretty cold hard incentive. You're going to be encouraged to get some IP that's commercially relevant if you know that you can then probably license it and get income from it. That would be preferred because you pay less tax on it. And then there's been a suggestion of maybe we should have what they call commercialization coupons, which is essentially a grant for commercializing research rather than just a grant for doing research. So that's what I want to say about Canada, and I set that up to basically so that you know that, there is some stuff and some programs going on at the higher level, at the federal level. And you want to, as a business, keep an eye on those just in case there's something there that you can leverage or benefit from. But that's all I'm going to say about, what's going on at a Canada-wide level. Let's go back down to what we're going to talk about the rest of our presentation, which is as a business. Maybe you have a business now or a potential business. Let's assume that business is in the software, computer technology space. Why bother about IP protection? I mean, presumably you've generated some sort of IP that you believe is valuable in the sense that it forms the basis of a product or a service that you are going to deliver or have delivered to the marketplace. And that's fine. You're going to make your money through sales. But why bother about IP protection? Is it because it's some sort of a vague insurance policy or something? Well, let's talk a bit about that, but a few thinking points first on the slide here. So we're going to forget about Canada, because even if you have an opinion on whether Canada has an innovation problem or doesn't, you obviously care about your own business. Maybe because you're in the software space, you might belong to what some have called the anti-IP hacker culture. So this is the idea that you don't want to put up walls. You want to build a solution, maybe a software-based solution using things like open source, etc., and deliver it to the marketplace and have something great that people are going to love. You're not in a fighting mode. You're in a collaborating and building something great mode. And it's fine to have whatever culture you want in your company. And I mean, what's the most valuable company in Canada right now? It's Shopify. And I think many would say that maybe they have a bit of that anti-IP hacker culture. So it's not saying you can't be successful. But the thing you have to watch out for, I would say, is that, if you become commercially successful, there's going to be other market players. They're not going to care about you. They're going to care about your customers. They're going to want, what you're delivering that's successful, they're going to want to deliver and have your customers be their customers. And those other market players might take different strategies and use different tools. A big, I guess if you call it a competitor of Shopify is Amazon. Amazon has like 10,000 patents plus. And so, different companies have different tools that they use to navigate the marketplace and their competitors. And you have to keep that in mind. And so how are we going to maybe think about IP rights even in that context? We'll talk a bit about that. Kind of lends to this next point. At minimum, you probably care at least about not being stopped from using your own IP to build something great. Or maybe you do want to go further. Maybe you want to stop your competitors from offering that same value proposition as you do. So in that context, how should you view and handle IP that you generate as part of your business that you consider to be valuable? Maybe it's going to form the basis of an aspect of your product or service. What should you do with it in terms of maybe some sort of action, purposeful action, whether it be like publish it or get a patent for it as applicable? What should you do? We're going to talk about that. People will talk, in talking about this, people will say, what you need, Mr. and Mrs. Business Owner, is that you need you need an IP strategy for your company. And what does that really mean? You could define that in different ways. But I try to look at it simply and say, your decision to take some action relating to formally protecting your IP rights really has to have a nexus to your business objectives that are very much independent of IP rights. It's just a tool. If you can't find that connection, then you don't want to spend the money and effort. If you can find that connection and it makes sense, then you probably want to do it. Now, there's kind of two business objectives that I consider that very much exist independent of IP rights, yet interface very well with them. One of those business objectives is the freedom to operate and innovate. So this is the idea that you want to go into the market and build something great, and you don't want someone to put up a wall. So I'll introduce a hypothetical example, and we'll refer to that maybe a few times in the slide deck. Let's say you own an e-commerce platform. So you have your customers are merchants who have a store on your platform, sell products to their customers who come onto your e-commerce platform and buy those products. You've recognized as a business that one of the things that's hindering, or you think may be hindering, your e-commerce platform from growing is that there are some people who don't really like shopping online. So my wife was like this pre-COVID. She didn't really buy stuff online. She liked to go to the store because she wanted to hold the object in her hand, kind of see what it looked like in her hand, relative size, and then go over to the cashier and check out in the traditional way. You've maybe decided as a business that one of the directions you want to go as an e-commerce platform is you want to try to bring virtual reality to e-commerce, because you figure if you can do that, if you can have like a virtual reality experience, then you can get more customers to go onto that e-commerce platform and visit this merchant stores, and your merchants are going to benefit, you're going to benefit as a platform. So you have this idea, and that's going to take a lot of development, but it seems like a good path for your business. So you're going to go down that route, and you want to deliver something that the market is going to love, that they're going to want, that's going to make people want to go to your e-commerce platform. You want the freedom to be able to build something great. Because here's the thing. Shopify also wants to bring virtual reality to e-commerce. Amazon wants to bring virtual reality to e-commerce. Walmart wants to bring virtual reality to e-commerce. I'll pick on Walmart because they're not a client of ours due to a conflict. So Walmart is a sophisticated company. They hold a lot of IP rights like patents. If you're a first mover bringing virtual reality to e-commerce, and they see you've built kind of the fundamentals, the pillars of some sort of solution that the market really wants, and that is good, it's a threat to them at some level, and so they need to deal with that. And one way to deal with it is to try to put up some walls to stop you, and that's in part why they have patents. They might come to you and say, you can't do that because that's going to infringe my patent, and use that as essentially a business tool to try to make it more difficult for you and mitigate some of the threat that they think you might be bringing. So you want to deal with that somehow. What's a good way to deal with that? How could IP rights help? We'll talk a bit about that. The other business objective, it's kind of the next step after freedom to operate and innovate, is that you might want to have an objective of commercial exclusivity. If you're going to bring virtual reality to e-commerce, you don't want Walmart to have the second mover advantage and saying, yeah, we're gonna do that too, and then because we're a bigger platform and because we're gonna make tweaks in addition to what your company already provided, they're gonna start. Walmart doesn't care about you; they care about your customers, so they're gonna start getting your merchants going over to their e-commerce platform. So maybe you want to protect that value proposition. You want to be able to stop, as you wish and as need be, other players in the market from offering that same thing that you're offering in the marketplace. And how can IP rights help support those objectives? Well, we're going to talk about that. We're going to talk about 5 IP tools, I'll call them. And I call it a tool because they're not always a right per se that you pursue. In some cases, they're an action you take. So there's 5 IP tools I'm going to talk about that I'll introduce. We'll have like one slide on each of them just to kind of give you a bit of background, because I don't expect you to have a lot of knowledge about IP. And then we'll talk about how they relate to those business objectives we talked about, and kind of how the puzzle, how it fits together in terms of a good way to view. So we're going to talk about patents. I'll have one slide on that. Design patents. I'll have a slide on that, and also one on copyright protection, trade secret protection, and something what I call defensive publication. So we'll talk about 5 slides, talk about each right on each slide, and then we'll go back to talking about how these tools fit in the context of business objectives. What I want to mention is that another sort of IP right/tool is your brand trademarks. Super important. I'm not discussing that here because we have a whole separate presentation on trademarks, and it's a little bit outside the scope because really we're talking about your underlying IP, mapping that to some sort of specific action that you can take, rather than the kind of broader idea of making sure you have a strong brand in the marketplace and protecting that brand. So let's talk for a couple minutes about patents. What is a patent? Well, a patent is essentially this government granted monopoly for an invention that you have. That invention is maybe like the underlying technology that's going to be the technical underpinnings of your product or service. That invention has to meet certain like legal criteria. It has to be new compared to what's in the public domain. It has to be not obvious, it has to be useful. There's certain things you can't patent, like you can't patent things that get too abstract, like abstract ideas, equations, algorithms per se. If though you have some sort of invention that you could spin or explain as being an improvement in technology or an improvement in how the computer functions, that's something that from a legal requirement perspective could be a good candidate for patent protection. Now, a patent can be valuable because if you have a patent on the underlying technology that is basically the technical underpinnings of your product or service that you're delivering to the marketplace, you can prevent others, i.e. your competitors, from being able to make, use, sell, implement that patented technology for 20 years from the filing date of your patent application, which is a pretty long life cycle, especially in software. And that can essentially give you a monopoly in the marketplace. Like if you are delivering something in the market to the market, and what is required technically to bring that into the market, you have a patent on such that your competitors couldn't do that, or at least they couldn't do it in the same way, then that can give you a big leg up in terms of your advantage in the market. Now, it's easy, if you think about patents, to think as maybe like the mad scientist in the lab coming up with something really amazing, or that data scientist you hired that's gonna who's generated or developed this like crazy machine learning algorithm or data analytics that forms the basis of your product or service. It's easy to think of those things, as inventions. But the truth is, in the software and computer space, the most valuable patents are typically the ones that are to inventions that are pretty boring, technically speaking. They have enough inventiveness to squeak by, but what they do well is they protect the broad technical underpinnings of something, some sort of value proposition that the market needs or really wants. And a good example of this is Amazon's patent relating to the one-click internet shopping, which is expired now. We're going back in time a good 20 years. Amazon engineers invent a lot of cool stuff from a technical perspective. If you look through their patents, you'd see they actually do a lot of things, whether it's like cryptography or whatever. But one of the most boring inventions, technically speaking, was this idea of the technical underpinnings of one-click internet shopping. So just in case you don't know what that is, you probably do, but just to be safe, this is the idea is where you, first time you go to Amazon and you buy something, you got to enter your billing and shipping information. But the next time you go back, there's a button on the screen when you're looking at a product page saying, hey, like buy now, click this button. You can click it and you don't have to re-enter anything. You don't even have to go to your cart. It just causes the whole order fulfillment service to begin. Now, this is something that it proves that the market really wanted when it was released. Customers really liked it because of its convenience. They didn't want to enter their information over again. Businesses, merchants, really wanted this also for a different reason, because of they like the idea of encouraging impulse buying. So I think many of us have been in a situation where you're shopping online, you add a bunch of stuff to your online cart, and then you decide afterwards, your brain is kicked in. Now it's like, well, I don't actually need that, or maybe I'll buy that later, and then you don't end up buying it. Like, they even have there's even a name for that problem. It's called the abandoned cart problem. With one click, it's like it gets you right at that moment of impulse. It's like, oh yeah, I think I really want this. Click the button, and it's purchased. Yeah, of course you could go through the pain of like requesting a refund and stopping it, but usually you don't. So merchants really wanted this feature. Customers loved it because it was just convenient that they didn't have to enter. But what Amazon did is that they didn't patent the idea of one-click internet shopping. Like, you can't get a patent on that. They didn't patent the look of a one-click button on the screen. You can't do that either. What they patented were the broad technical underpinnings that sit just underneath the surface that allow one-click internet shopping to exist. So the idea that, okay, what happens here? The person clicks the button, and it's essentially an HTTP request that goes to a server. You got to pull a cookie out of that. You got to get the idea of the cookie. You got to send it to a server to pull like information that's stored in relation to that ID. And then you got to send that to an order fulfillment server. So they captured those broad technical underpinnings such that if anybody wanted to implement one-click internet shopping, they would have to essentially infringe this patent, because they would have to provide those technical underpinnings. There's no other way around it. They're able to get a patent on that, and it upheld challenges. It was considered to be inventive enough given the state of the technology at the time. It by far proved to be Amazon's most valuable patent. It's rumored that Apple paid $1 billion in licensing fees to use this one-click technology in the iTunes store. So the take-home point here is that, forget about the legal requirements of getting a patent right now. If you're just doing that initial look of saying, if I was to spend money getting patent protection, where would I want to focus? From the business perspective, don't worry so much about what your engineer thinks is cool. Think about, what is my value proposition that I'm bringing in the market, and can I protect the broad technical underpinnings of that such that I could stop a competitor from being able to offer that same value proposition in the market. And it might be kind of a boring invention, but if it has enough inventiveness to squeak by, you're going to be okay, and it's going to be potentially very valuable for you. So that's patents. Another tool is design patents, or they're also called industrial designs here in Canada. This is like a patent, but instead of being directed towards kind of an underlying invention or functionality, it's really protected. It really protects the ornamental feature, how something looks. So you see design patents like on pieces of furniture, etc. In the software computer space, they're not super valuable, generally speaking, because they're usually pretty easy to design around. You get a design patent on your user interface, your competitor will just do the same thing, but just a little bit different user interface. But there's good to know about, because there's the odd time where they could be handy, and there have been examples of valuable design patents in the past. Apple, early on in the smartphone era, was able to get a design patent on having the look of a grid of icons with kind of rounded edges in a grid pattern on the screen of your mobile device. Guess what? That's become the de facto standard. Whether you buy like Android operating, excuse me, wait. Whether you buy Android operating system or Apple operating system, the customer expects now to see, like when they look at the mobile phone, kind of this grid of icons. It's just how it's done. that's what the market wants. So Apple was able to get some design patent protection around having that look, and that was valuable to them. In fact, if you go back like a decade ago, there's what they called like patent wars, around patents and design patents that relate to these sorts of features. This copyright protection, when you think of copyright, you think of like, oh, I wrote a song, I wrote a book, so now I have copyright protection. You can't copy that or publish it without my permission. And it's true. I mean, copyright protects original works of authorship, but the thing to note here is that software code itself is copyright protected. So there might be instances where you can rely on copyright protection, and we'll talk about briefly later kind of where that fits in terms of compared to other IP rights. Then there's something, it's not really an IP right per se, it's more of an action you can take. You could, for a piece of IP that you've developed, you could say, you know what, I'm going to defensively publish this. That means I'm going to maybe write a white paper or something. I'm going to put it on the internet, get it in the public domain. Doesn't mean you have to email a copy to all your competitors. You can do it somewhat discreetly, but still being public. And the idea here is that, okay, I'm not going to get commercial exclusivity because I'm basically giving it to the public and explaining what I'm doing, but at least it could potentially limit the ability of my competitors to patent that and stop me if they happen to independently be developing it. Talk about where that might fit. Lastly, but not least, is trade secret protection. So this is the idea that, you know what, I'm not going to like apply for a government granted right. Like I'm not going to get a patent or something like that. I'm just going to keep my IP secret. This in the software space, this is Google's search algorithm. The current version of their search algorithm, it's a trade secret, and they tweak it. Trade secret makes sense a lot of times when it's something hidden on a server that's hard to reverse engineer, like Google search algorithm. The thing though to note is that just because you decide not to publish it doesn't mean it's automatically a trade secret. You have to treat it as a trade secret, which means taking active steps like virtually or physically partitioning the code, limiting access, having company protocols relating to it, educating employees on those protocols and confidentiality agreements, etc. The idea being that if you do this, first of all, you're more likely to keep it secret. And second, if say a rogue employee or something misappropriated that trade secret and you had to take some action against them, like in court, you need to show that, yeah, I considered this a trade secret, and that employee, they knew it was a trade secret, and I had all these steps in place, and they broke those steps. So here's our 5 tools: patents, design patents, copyright protection, trade secret protection, and defensive publication. Let's talk about where they fit now, going back to these objectives of freedom to operate and commercial exclusivity. And when might it make sense to kind of focus more on one IP right over the other? Another way of kind of asking this is, okay, I've developed some sort of IP in my business and I consider it valuable. What am I going to do here? How should I handle it? Well, and that's going to be in the context of maybe those business objectives. And I'm going to draw a little grid here. On the bottom axis, we have your freedom to operate and innovate objective. Vertical axis, we have commercial exclusivity. Let's start putting some of these IP tools onto this grid and talking about when it might make sense to pursue one over the other in certain situations. Let's talk about patents. So if I were to put a patent on this grid, I would put it high up in terms of its commercial exclusivity value that it offers. Because, for kind of the reason I talked about earlier, if you have a patent on an underlying technology of some sort of product or service in the marketplace, you can prevent others, your competitors, from making, using, selling, implementing that patented technology without your permission. In other words, you can exclude them. In fact, a patent is best thought of as a right to exclude others from practicing that invention that's patented. So it has high commercial exclusivity value, potentially. I would also put it high, relatively speaking, on the freedom to operate and innovate side of things, because of its defensive leverage. So going back to our hypothetical example of you run an e-commerce platform and you want to bring virtual reality to e-commerce. You want to be able to build something great and not have some company like Walmart putting up walls against you. Well, if you moving into this space, start to patent some of the pillars of what is required to bring virtual reality to e-commerce, and you get some patent protection on that. Now you have some patents that, if you chose to enforce, could hurt others who want to also bring virtual reality to e-commerce. And this provides some kind of back-off defensive leverage, almost like reverse ammunition, you could say. A sophisticated company, if they're thinking of putting up a wall, like saying that you infringe on one of my patents, they have a look at your portfolio and they see that you have some patents in there that kind of protect the pillars of where that company wants to go, then they're gonna think twice and be more hesitant about getting in some sort of patent battle with you. Or maybe you might actually end up collaborating in what they call cross-licensing the patented technology. So if you like some of the patented technology that the other company has and vice versa, you have it kind of to collaborate rather than to compete, and there's freedom to operate value there. So, well, that sounds good. How about we just get a patent for everything we can, because it has good commercial exclusivity, good freedom to operate. We don't do that. You know why? Because patenting is expensive. You can spend tens of thousands of dollars just getting a single patent in the US on a single invention. And the upfront cost is quite significant. Hiring a competent IP practitioner to draft it for you, filing it in the patent office, that's going to probably be over $10,000. So with patents, you have to put quality over quantity. You got to think really hard about whether it would make sense to get patent protection. And to help do that, what I suggest is putting a sort of filter on patents. I see there's a question here. I'm just going to finish this sentence and then we'll go to that question. So you want to apply a certain filter to determining whether to seek patent protection or not for something. And I would say that filter is that you got to ask yourself, this underlying IP, if I were to get a patent on it, would that protect a user experience that's valuable, that my competitors would care about? If you don't want to get a patent on something that your competitors don't really care that much about because they could just compete with you and just not implement that. You, in addition, want that thing you're thinking you get a patent on to have a long life cycle, which is important in the software space. I mean, software companies will move quickly, and a lot of times it just doesn't make business sense to get a patent. But not everything in software has a long life cycle. The Amazon one-click's a perfect example. The other criteria you want to provide is also this thing that I'm thinking of maybe getting a patent on. It has to be detectable. If you can't tell if someone's infringing it, then it's not going to be that helpful to you. And finally, you want to ask, can you patent it in a way that's going to be really hard to design around? If you don't think you can meet all that criteria, then probably not a good candidate for patent protection. If you can, then you want to think about it more seriously. There's a question. Leah, do you want to help minister that, please?
Sure. So we have here a question. First, we recently started filing a patent, and in the middle of the way, another corporation in the States published their patent that is pretty much the same idea as theirs. So now if we go ahead and sell the product in the Canadian market, what will be the consequences? Is there any way we can still bring the product to the market?
So, there's a few things there. It's a pretty specific question, but I'll give a few thoughts here. So just to recap that without repeating the whole question, business files a patent application. They realize another corporation has published their patent. looks like it's kind of the same ideas here. There's like a collision going on. Now what? Can you sell the product in the Canadian market? So a couple things. First is that patents are territorial. So if another company has a US patent and they don't have a Canadian patent, then you can't sell in the US market if you're infringing that patent, but you can sell in the Canadian market. Second, I would say, is that you know, if this other company has published a patent, you got to look at more than what did they disclose, but what does that patent actually cover? Would the claims of that patent at the end read upon what you're doing? Because not everything in the patent is protected by the patent. You have a disclosure, and then at the end you have the claims, and it's the language of the claims. If what you're doing falls in the scope of those claims, that's where you should be concerned. That you want to get an opinion on that. You don't just want to figure that out yourself. Also, you know, there's a timing issue here. If you've already filed a patent application and maybe you did it before the other company, then it might be the case that you're the one who's entitled to the patent. So I know that maybe doesn't answer everything, but it gives some kind of high-level ideas to think about.
I would say then there's a follow-up on that one. Maybe if we're just already answering questions here, Jeff.
I just got to find that follow-up. I can see it's more, but I don't see.
I'll be able to read it to you because it's in the chat.
I found it. So,
are you good? Okay, perfect.
So if that US company has published their patent solely in the US, could the Canadian company file for a similar patent in Canada? You know, without getting into like legal advice on that, because I don't know all the specifics. Generally speaking, probably not, because you can only get a patent if it's new and inventive over what's in the public domain. And by what's in the public domain, they mean anything published anywhere in the world. So, because you know, the idea here is that from the government policy perspective is that they use patents as a kind of tool to help get things into the public domain, with the idea being that instead of keeping it secret, you'd apply for a patent and you might get a patent, but in exchange, you published it. So if it's in the public domain already, then you're not going to get a patent for it in any country, really, any country of interest. Okay. I'm going to continue on, and then and then we'll maybe take it from there, and we can go back also to questions. We can come back to it after the presentation too, if there's a follow-up question on it. So we're talking about you know, mapping these different IP rights to kind of business objectives. We've said, okay, a patent can look good from a freedom to operate and a commercial exclusivity perspective, but you're not going to just get a patent on anything. You really got to have some tight criteria, because it's going to be expensive to get a patent. It's got to protect. The patent's got to protect your user experience. It's got to have a long life cycle. It's got to be detectable if someone's infringing, and you got to be able to do it in a way that's going to be hard to design around. Guess what? Amazon one-click had all that. They protected the one-click user experience. It's a long life cycle. It's going to be around forever. It's easy to detect because it sits just underneath the surface. You know if someone's doing one-click. And they were patented in a way that was hard to design around. So maybe patent's not the right action for that particular piece of IP you have. What's another option? Trade secret protection. I wouldn't put trade secret protection as high in terms of commercial exclusivity or freedom to operate as a patent, because if somebody independently develops it, they you know, can also practice that in the marketplace. So there's not as much commercial exclusivity. They also potentially, if they developed it independently and maybe first, depending on the specifics, they might be able to get some sort of patent or IP right on it and potentially stop you. But in general, if it's something, you know, that is hidden and hard to reverse engineer, then it could be a good candidate for trade secret protection. Trade secret protection actually, you know, a lot of times it protects like the crown jewels of a company. It's like what is often valuable to a software company. It's like the data that you've collected. You can't get a patent on data. Know-how of employees in the company. You can't get a patent on know-how. Maybe it's some sort of machine learning analytical or search algorithm or something that sits on your server in the cloud. You can maybe get a patent on that, but then how are you going to know if someone's is infringing it? So a lot of times trade secret protection is very useful for many things in the software space. Another action you could take is you could say, you know what, I have this IP, but I'm going to publish it, put it in the public domain, because at minimum, then at least I can stop others from getting a patent on it. Kind of goes back to our question we just talked about. It's like, if you publish it, once it's in the public, no one else can file a patent for it basically anywhere in the world. So when would you do that? Well, first of all, you have to recognize that there's no commercial exclusivity value in doing that, because you're just giving it in the public domain to your competitors. But there could potentially be some freedom to operate value there, because by putting it in the public domain, you can't, someone else can't get a patent on it and put up a wall against you. So you might do this when you've looked and said, you know what, this particular piece of IP doesn't make sense to patent, doesn't make sense for trade secret protection, but I want to help ensure some freedom to operate and innovate. So I'm gonna put it in the public domain. And there's different ways of doing that. You don't have to send a copy to your competitors. You know, you can publish it in a way that's somewhat obscure and discreet, yet clearly within the public domain. Another option for you is design patents. Remember, these are like patents, but are directed towards ornamental features. So because they're kind of like patents, I would put them on the same level as patents in terms of freedom to operate and commercial exclusivity. But you know what, they're not going to be as valuable in general because they're limited to ornamental features. Maybe consider the user interface. I see another question. I'm just going to have a look at it. Can you explain more about the infringement issue of patents? What level two patents can be similar but not considered infringement of each other? Can someone patent something that has small elements of various patents when combined or considered? So there's a few different kind of issues going on there. One is, can you explain more about infringements of patents? Yes, I can. So a company gets a patent. It's ultimately a patent that's just in a particular country. So you can get patents in most countries in the world, but it's very expensive. So typically a company will just get a patent in a few countries that are key interest to the markets. Maybe like US, in Europe, maybe Asia somewhere, like China, maybe Canada. So if you're doing something, it doesn't matter whether you have a patent or not. If you're doing something that infringes that patent, then they can take you to court essentially and stop you, or make you pay some sort of fee, some sort of penalty essentially for your infringement. Now, just because at the end of patents, there's these things called claims. They're essentially single sentences that set out what the patent covers. They are supported by the detailed description of the patent, but they're not the exact same scope. So one would have to look, if they're thinking that they might be infringing a patent, that they're actually infringing the claims of the patent, not the description of the patent. You can have two patents that can seem very similar when you read their descriptions, but they could both be patented to kind of different inventions because maybe they're patented to different aspects of a single disclosure. One can also, the other question here was, can someone patent something that has small elements of various patents combined? In general, in general, that's how inventions are made. Actually, it's like you take a bunch of things and you put them together, and now you have instead of an aggregation, you have a combination, something that's synergistic. You know, what's a bicycle? It's a combination of different parts. Each of themselves, might be known, but you put them together in a certain way. So you can, if you've come up with something that's new, that's based on elements of other patents, you put it together, yes, you can get a patent on that. Now, but you got to be careful here, because if you are making or using or selling that, if you're using those elements that have patent protection to build your product, then you could be infringing that patent. You're not doing it if you purchased it. The other question is that if we use open source code as part of our software, can we still patent it? And the answer there is that it gets complicated, and I'm not an expert on this. Some open source code have open source works because it basically has software licenses that define what you can and can't do, or what you have to do, like share the modified source code. So some source code licenses actually have limits around what you're able to patent. But generally speaking, if you use some open source code and you've modified it in some way, and basically if you're protecting something by a patent and in implementing some aspect of that, what you're protecting, you've used some open source code, you're probably going to be okay. So I will continue on. We're talking about the different IP rights, mapping them to commercial exclusivity and freedom to operate. The last one, though, I haven't talked about is copyright protection. There may be instances where you just want to rely on copyright protection, which is automatic for your software code, and not worry about, a defensive publication or getting a patent on it or a design patent. Copyright, it has pretty low commercial exclusivity value because one could do the same thing using different software. Its freedom to operate value is really linked to whether you publish it or not. But it's just something to know that you can fall back on as automatic copyright protection for things that maybe are software implementations that are not overly commercially valuable, but you want to do something. But copyright protection is automatic, so you don't actually have to do anything. Now, so I think that the take-home point on this slide is that, you want to have a look at your IP that you've developed or that you are developing. And for every piece of IP that has some sort of value to you, you want to kind of map it to, what should I do? Nothing? Or should I do patent protection? Does that make sense? Or should I do defensive publication or trade secret, or just rely on copyright protection? And help answer that, this slide would put it in some context in terms of what are your goals, commercial exclusivity versus freedom to operate, and what criteria does that piece of IP meet? If you care a lot about commercial exclusivity and freedom to operate, and that piece of IP meets the criteria of it's going to protect the valuable user experience, long life cycle, detectable, hard to design around, okay, now you start thinking about patent protection. If it's something that's hidden on a server, hard to reverse engineer, or something that's questionable whether it's patent eligible at all, okay, let's maybe think of trade secret protection and then go down that route. So this is a bit of a rule of thumb guide to help you out. Every fact pattern is different, of course, but at least maybe it gives you a starting point. So we've had some questions about patents. People are interested in patents. Let's talk a little bit more about what types of inventions in the software space you should patent. It's a generalization, but I like to think of software as having 3 layers. I see there's another question. I'm going to finish the slide first, and we'll do that question. So I like to think of software as having 3 layers. And this is a generalization, of course, but in your outer layer, you have what you might call the user interface. This is what the what the customer sees. And the thing with the user interface is it's really important because it protects it shows your brand. It's what your customer is going to be interacting with. It frames their user experience. But you know what? There's not necessarily a lot of good candidates for patent protection at that level, because often it's like things that are short life cycle and easy to design around. Maybe you could get a design patent, but even then it's questionable. Unless you have some good machine-human interaction going on, like, I move the mouse in front of this icon and the mouse disappears, something, machine-human interaction like that. Unless you have something like that going on that's valuable, there's not a lot going on in the user interface that you would necessarily want to patent. In the other end, in some software implementations, you have these core algorithms like data analytics, machine learning, search algorithms, etc., that maybe form a fundamental basis of your product or service. And there might be some pretty amazing stuff going on here, but what about patent protection? Just because it's amazing doesn't mean you patent it. I mean, think about this. It's an algorithm that's probably hosted on your server in the cloud. It's going to be code that you're not distributing to customers. Its detectability is going to be really hard, so you don't even know if someone else is going to be infringing if you got a patent on it. Trade secret protection is probably a good route for you here, like what Google does for their search algorithm. Then what you're left with is kind of the non-sexy stuff in between, which I'll call the platform, which includes the platform-related elements that help support the user experience. Here is where I think there's potentially some good candidates for patent protection. You got some software-hardware interaction, which helps with kind of the legal requirements of patent protection. You got some better detectability because it just sits underneath the user interface. There could be something really good there. And the Amazon one-click patent is a perfect example of that. They didn't patent, remember, they didn't patent the look of the button on the screen, the user interface. They didn't patent some sort of core underneath algorithm. They simply patented the technical underpinnings of the platform that's required to implement one-click internet shopping. And they did it in a way such that anybody who wants to offer that in the market would have to implement their platform, their technical underpinnings in that way. Hence, it became quite valuable to them. Okay, I have a question here. Is there a reasonable expectation that the first patent program is forthcoming and to wait to the initiation of that process after the upcoming budget rollout? I would say there's not a reasonable expectation that that first patent program is going to be part of an upcoming budget at the federal level. I suspect we won't get that, but you never know. If I had to guess, I would say no. That being said, at the provincial level, I think in Quebec, they have one. So you could look into that, particularly if you have a business address in Quebec, but I don't know a lot about it. Okay, a couple more slides. We're gonna finish off soon here because I know it's been, you've sat through several slides now, put it that way. So patenting strategy, software, and software as a service. You know what, if you're kind of thinking about patenting strategy, a lot of companies a good place for them to start is what I'd call a product-driven strategy. So this is like asking questions about what you are delivering to market or want to deliver to market. Questions like, what does the customer love about this product or potential product? What's the design cycle of it? What parts of this product would be detectable? If I got a patent on these things, how hard would it be designed around? What's my value proposition here really in this product over the competitors? Asking business questions like that to guide where you want to patent around your product, rather than technical questions like what's new, what's non-obvious. Well, you got to deal with those, but you need a short list first of what makes business sense to patent around your product. So a lot of companies will kind of focus on this or start with this, but another sort of strategy to complement it is what is called a technology-driven patent strategy. This is asking questions like, forget about my product. What are my competitors doing? And where is the market going? Can I envision, let's say I know or predict with, I feel very confident that virtual reality is going to come to e-commerce in the next 5 years. Okay, so what do I think my competitors are going to be doing in that space? And what can I sit down now and strategize and say, what would you need as pillars of a solution to bring virtual reality e-commerce, and get some sort of broad patents on that, and then see where the market goes. And now I could have something that could be very valuable from a patenting perspective. It's a little bit, they call it predictive patenting. It's kind of like, it's looking at the market and what competitors are doing and trying to go in that direction before your competitors do. And then keeping the patent families alive and tracking to see if the technology is adopted. If you're interested in funding, anecdotally, I'm not an expert on this, but anecdotally, private equity, VC investors seem to really kind of like product-driven patents because, it's really kind of helping protect revenue streams around something that's tangible, your product. More strategic investors are happy to see broader, speculative, technology-driven patents. And if you want to go public as a company, you would be well served to have a larger portfolio, a mix of both product-driven and technology-driven patents. So, finish it all off. A big take-home point here is that there's just more business sense in trying to control access to technology, or being a gatekeeper. Doesn't mean you have to shut out people you want to collaborate. Doesn't mean you have to be a nasty market player. But having things in your toolkit that can be useful for you in navigating the market is going to be very helpful. And you being able to control someone else, another market player, having access to that technology that you have is going to give you an upper hand. How do you do that? Well, using enforceable IP rights like patents are a good way to help achieve that. And even if you look at stuff like open source, these things that the anti-IP hacker culture, if you call it that, they're only successful because IP rights are used to enforce behavior. Otherwise, you're going to get some company, who's going to take open source, they're going to make some modifications to it, build something better, and they're not going to share or make available that modified source code. It's the software licenses around open source that control and enforce the behavior, and that's basically an IP right. At minimum, you obviously care about freedom to operate and innovate. That itself, I think, is a strong incentive for thinking about IP in the way I've discussed. So if you have some valuable IP, crystallize that in some way in action and leverage it. That's basically it. So I'm just going to jump right to questions. I see there's one that has come in. I'll read it here in a second. If anyone else has questions, please.
I would say we're going to jump right in, Jeff, and then while we answer the first question, I know we'll have other questions coming in.
Yeah. So Colin asks, can you speak at all to the issue of patent trolls? So if you haven't heard this term, a patent troll is essentially you could maybe say derogatory, a nickname for companies that in particular have a business model where they obtain patents. Sometimes, for example, they purchase them from companies who either have no use for those patents anymore or who are going bankrupt. And they take those patents and they look for products in the marketplace that might be infringing those patents. And then they go to those market players and ask for a license fee, or otherwise they'll sue them for patent infringement. There's different levels of what you might call trolls. So there's ones that are the ones that kind of made the headlines, especially about 10 years ago, where they really weren't practicing fair business practices. That they were taking these patents and they're infringing like restaurants and that, their claims were very not on solid ground, and they're going after these small players who didn't know and rather just pay a relatively small amount of money to make them go away. Those, it's a business practice that irritates a lot of people. Then there's ones that are a little bit more strategic about it and smarter, and I think fairer about it. And you could argue whether they should be called trolls or whether they're just being reasonable. So, this has been going on for years. Like a company like Texas Instruments, would acquire patents and would try to enforce them as a business model. What I can say is that, we, in the software space, there were a lot of patents in the earlier days of software, like go back 15 years or so ago, 20 years ago. There was a lot of patents that were broad and were granted, in part because it's like, when you're at it, when it's like a nascent technology, when you're at the start of things, it's easier to kind of push through and get patents granted for things that are broader. So there's kind of and examiners weren't used to examining software inventions. So we had this little phase around 25 years ago where a bunch of patents were granted for software related inventions that were really probably too broad, and some patent trolls got a hold of those and made some headlines in the market. That still goes on, but it's not as bad as it used to be, and there's not as many of those garbage patents out there anymore because their time has come and gone. So that's what I'd say about patent trolls. I wouldn't be too worried about them. It's just, but if you become successful, people will come bugging you, patent trolls, etc. And most of the time, you can deal with it in a way that's pretty efficiently. Next question, can you provide some thoughts on the APIs? If I'm creating a platform integrating another company's APIs, what should I look out for? And are there any concerns which you would raise? It's getting a little bit outside of my expertise. When a company offers an API, I assume they've either offered it publicly, in which case you can use it, no problem, or they've offered it under the terms of some sort of agreement with you, in which case you got to make sure that you're abiding by that agreement. If you're building something, let's just say hypothetical example. Let's say you are. We'll continue on with e-commerce platforms, and you are calling an API from a shipping company to get data related to where the product is in the shipping process. And then you're going to do something with that data that's inventive, process it in some way and present it in some way to the merchant or the customer. You don't have to be too worried. You can get an invention, you can get a patent on what you're doing with the data you pulled from the API, as long as you're meeting the terms of the API agreement. That's what I'd say generally, with the caveat that it's not legal advice, and also it's really outside of my expertise. I'm just kind of talking off what I think is reasonable based on what I have seen. Okay, I think
we have another question in the chat.
Okay, yeah, let's go to the chat here.
Do Smart and Biggar have a startup support program? This person is looking for trademark and legal contract support.
So what I would say is that the best thing to do is to kind of continue through Invest Ottawa. We have some IP legal clinics that we run, where essentially, I think we have them once every other month, where you can book a time. I think it's like a half hour, to basically free to talk initially with an IP practitioner from Smart and Biggar. And that's probably where, that would be the best place to start. We don't have something like a official outside of kind of partnerships with organizations like Invest Ottawa. There's also a question in the chat about the slide deck. Oh, Leah just mentioned it, or yeah. You're going to get a copy. So it's no problem that you're a bit late. Okay, well, I see another question here. Ryan asks, there are 3 companies who have patents in Canada and US for a system that's similar to one we have just designed. How can they have patents with claims that are so similar to each other? Before we launch our product, should we focus on creating a similar patent or on licensing? Okay, so again, these are pretty specific questions. I'm not giving legal advice in these presentations, but I'll give you some thoughts here. So this company that you're concerned about, it has 3 patents, and you look at those claims of those patents and you say to yourself, as you are, Ryan, how can these have claims so similar to each other? That means how can they have basically 3 patents that seem to be kind of directed towards the same invention? Well, you are able to get patents for inventions that are, you can only have 1 patent per invention, but in practice, you can often get patents that are related to each other that are very close. So I think if you were to read those claims and you kind of had the eye of an experience of an IP practitioner, you might kind of see that they're very similar to each other, but there are some differences here that could be considered to distinguish. the threshold, especially in the US, the threshold is such that as long as they're kind of related, you can get more than one patent on the same variation of the invention, just still slightly different. As long as one is novel, as they call it, it's a little bit different compared to the other. Those patents are often bind it together, though, like they, in the terms of that they all expire on the same day, and if that company was to license them or to maybe not license them, but to sell them to another company, they have to kind of go as a package. So you would be surprised kind of what you might see out there if you're not used to looking at patents. So next question related to that was, before we launch our product, should we focus on creating a similar patent or on licensing? Well, first of all, before you launch your product, you want to you would probably be well served to making sure that you aren't infringing those patents. So you could get an opinion on that. If you think there's a chance you're infringing, you could approach about licensing. Creating a similar patent might not do the trick, because first of all, it would have to be something that's not novel and inventive over these previous patents, so it can't be too similar. And that other company's not going to care if you have that patent, unless you're literally getting a patent on something that they're going to infringe. That they're going to infringe. So I think if I were you, I'd focus more on the side of making sure that you're not going to be infringing those patents, and seeking a license as need be. Okay. So I don't see any other questions. Do you, Leah?
I don't see any on my side.
No problem. Well, I mean, that was a good number. So thank you, everyone. So I'm happy to, if someone wanted to contact me, if they have any general questions. As Leah mentioned, this recording of this slide deck is going to be available. The best thing, if you kind of want to get into the particulars of something, the best thing to do is probably not email me, but sign up for one of the IP clinics at Invest Ottawa, where someone, it might be me, but probably one of my colleagues would be there, and you can kind of get into a bit more of a conversation about your particular issues that concern you.
I'm just pulling up the sheet of the upcoming IP clinics that you just mentioned, Jeff, just to give people maybe an understanding what we have planned. They're not published yet, but just as a heads up for anybody who would be interested in. So we have the next one coming up on the 21st of April, again with you, Jeff. It will be about IP strategy from bricks to clicks, protecting trademarks and copyright online.
But just sorry, Leah, before you go on, that's actually not me. That's probably
not you. Okay.
I think it's actually my colleague Dan. But
okay.
So that's a presentation. Mm-hmm. But I think my understanding is that Smart Biggar also has these what they call IP clinics. So every couple of months.
Okay.
I don't know who is it on your side. I can't remember.
Yeah.
But every couple of months, and you probably can find it on the Invest Ottawa website.
That's true.
People from Smart Biggar come. Well, pre-COVID they came on site. Now it's virtually, and people can sign up for I think it's 20 minutes appointments maybe.
Exactly. You have to pre-register and you can sign it. I'm sorry, I misunderstood you, but you're correct. We have those sessions coming up where you can pre-register and you get a one-on-one with somebody from Smart Biggar.
Mm-hmm. Yeah, good.
Okay, as I said in the beginning, I'll be following up with everyone with an email with a link to the recording and also a copy of the slide deck. In that email, I will also include a survey link where I would really be thankful for if you'd fill it out. Take your time, only 2 minutes, but it will give you the opportunity of letting us know how we did today, and also if there are any other topics you would like us cover in the future. And with this being said, thank you so much, Jeff, for being here today and sharing all of this with us, answering those questions. And also thank everyone else for being here. And I hope to see you again in a future session of ours.
Okay, thank you. Take care, everyone. Bye-bye.
Bye.